Yeah. Hello everyone. My name is Rohit Sharma. I'm currently practicing in Hyderabad at the law firm called Tatwa Legal. I'm an associate over there. And today we'll be briefly discussing about the topic of recovery of debts due to Banks and Financial Institution Act 1933. As this topic is somewhat similar to the topic which I covered in my last session, that was SARFAESI Act, and this whole RDDBFI Act. For the ease of this session, I'll say it RD Act throughout the session. So this whole RD Act is somewhat on the lines of insolvency process and recovery of the money. So I have jotted on all the important topics that are necessary within this act. I have included all the points of jurisdiction, procedure, appeals, and different amendments. And I have also done a brief comparison between RD Act and SARFAESI Act. So as we progress, we'll surely discuss on that. But before starting the session, I would like to just give you a brief summary about the whole situation as to what we are dealing with, what is RD Act, what is the whole background of this situation. So the problem of debt and insolvency surged in the year 1990 when the Indian markets were open for the world. So Indian market and Indian borrowers were expecting a lot of investments from investors within India and also outside India. So with the increased number of investments, there was also an increase in the number of debts. And because of, as I also mentioned in my last session, because of the lack of the economical knowledge with the Indian players have in the market, there was this whole cycle of lending, borrowing money couldn't place properly. So there was a lot of debt that was created in the market. So and because of that, there was a lot of, I would say, a pressure on the traditional judicial system, and the courts were under a lot of pressure. So the government came up with an idea to start a different quasi-judicial process to cope up with this problem. So initially, if I remember, in the 1981, there was a committee which was head by Mr. M. Tiwari, where he initially suggested the idea of quasi-judicial authority to cope up with this problem of debt recovery. And it was discussed briefly, and the report was prepared. And followed by that, later in the 1991, by the committee led by Mr. M. Narasimham, if I'm not spelling it properly, forgive me for that. Mr. M. Narasimham finally concluded that report and finally came up with this act of recovery of debts due to Banks and Financial Institution Act 1991. He concluded this, and it was finally notified by the government in 1993. And what was the outcome of this act? This act basically brought the existence of DRT and DRAT. Now, what is DRT? DRT is basically a debt recovery tribunal, which is basically a tribunal or authority which is dedicated for debt recovery only. Because, as I told you earlier, because of so much increase in the number of debts, the traditional courts were already under so much of burden. So, to cope up with that, they brought the concept of DRTs. Now, still starting from 1990s to today's world, DRT is still prevalent and it makes much more sense. I would say NCLT has taken a bit of edge over DRT because of the pecuniary limit and other factors also. But from the inception till today's date, DRT is prevalent and is helping the cause for which it was started. So yeah, in today's session, we'll briefly try to cover about what is insolvency, what is the process, how are these authorities called as DRT, NCLT, how are they helping in reconstructing of the security, how are they helping in recovery of the money, what are different kind of securities, what are different kind of process through which we can recover the money, and so on. So starting with the few milestones of this act. The Act facilitated the creation of 39 DRTs and 5 DRATs across India, and each equipped with specialized officers to handle financial cases. Initially, the Act applied to the debts exceeding 10 lakh. However, recognizing the need to address a broader range of cases 2016 amendment, which I've also explained as we progress. We'll see in the PPT which I've prepared. The 2016 amendment reduced the threshold to 1 lakh, thereby expanding the scope of tribunal jurisdiction. So this amendment to make from pull it down from 10 lakh to 1 lakh, that was specifically done for the matters related to SARFAESI. That also we'll deal later on. Yeah. So the next one, the establishment of DRTs aim to expedite the resolution of debt recovery cases, reducing the time and complexity associated with the traditional court proceedings. So as I told you, because of the number of increase, because of a increased number of all the debts that were created in the market throughout the banks, the financial institution, the non-banking financial institution, and because of such large number, that it was not possible to find a solution, because a debt, a case, a problem where money is involved, we surely we can't do a amicable solution for that. I know arbitration is one of the possible ways out for it, but it was not back then. So for that they wanted, so it was that for, yeah, so that's why they opted for DRT. And the major purpose for DRT was to have a process which is almost like a fast track process and gives provides recovery at the best possible way in the minimum period of time. Despite these advancements, challenges such as case backlogs, enforcement issues persist. Ongoing efforts were made to address these shortcomings and enhance the effectiveness of the debt recovery system in India. I will briefly touch upon the objectives of the RDA Act. The objective is to provide a specialized system to address the recovery of debts due to banks and financial institutions. Now, I'll just like to give you a small example. So, I know we are discussing about this whole process of DRT, debts due to the banks and financial institution. You guys might be wondering, why is it so important to focus or to give more weightage to the debts which the banks or the financial institution give? Why can't, just like any other fraud, or why can't like any other default between two parties, they can't go to, why can't they go to the traditional court? Why do we have to create this whole structure of DRTs, NCLT, and also on? So I would like to say that banks are one of the very crucial, and it's like one of the pillars to keep the economy going, because banks generally keep the money, the deposits of the common people. And let's say, for I would like to give an example, I would like to explain the situation and nature, that how the banks which are kept how the debts which is, how the money or the funds which are kept at the bank, and if that bank goes bankrupt, or the bank has given a loan amount to a party who has gone bankrupt, and now bank doesn't have the sufficient fund for the survival, then how it can affect the economy. So very famous example I would like to give, during the early 2000s, there was a person named Vijay Mallya. He got around 10,000 to 15,000 crores of loan from the bank by just showing the projections of his business. He didn't give anything in return. There was no property kept as collateral, and just by, I think so. If I've read many articles, and they've explicitly said about that, the how the corruption and how there were many anomalies in that procedure, that keeping all the RBI regulations aside, many, I think so, the officers of in that bank, which I don't want to name, they gave the money to the Vijay Mallya by just keeping their projection in the mind. So things were going good till the company was making the profit. But later there was no profit generation, and Vijay Mallya's company went bankrupt. But the 10,000 crore which he took from the bank, that money that the bank led to Vijay Mallya, that was owned by the common individual, the common layman of India. And because of that, the whole structure collapsed. The economy was affected at a very large scale. So to cope up with all such problems, because if a bank faces a problem in India, which is a regularized bank, which is a nationalized bank, which is what do I say, which is also affirmed by the RBI, and if that bank is facing problem with such huge amount of debts which people are not repaying back, then it is somewhat like a percentage of GDP where it gets affected. To cope up, so to cope up with all such mechanisms, to cope up with all such debts, this whole fast track procedure of DRTs, NCLTs, and all these insolvency laws are got into picture. Even starting from the Sick Industries Act, SICA Act, then this RD Act came into picture, then SARFAESI came into picture. All these acts had certain advantages and disadvantages, but later came IBC, Insolvency and Bankruptcy Code of India in the year 2016, which was later also amended in 2019. This is a much more reliable mechanism for a debt recovery and which is followed prevalently throughout the India. Unlike DRT, where it is a tribunal, a quasi judicial authority, NCLT is also working on the similar lines, but the pecuniary limit is much higher and it has little more complexity and a little stable procedure. I would like to say DRT procedure is little fast track, but NCLT takes little more time because we have more number of days given for relaxation in NCLT, but not in DRT. Also, once the matter is gone from NCALT, it goes to High Court or Supreme Court. And once the appeal is gone to the higher court, then it is just like any traditional court practice, and it generally takes time. That is one of the key differences. So, sorry. So yeah, so we'll try to focus on the objectives to provide a specialized system to address the recovery of the debts due to banks and financial institution, to focus on the reducing the non-performing assets of the bank and financial institution, create a balanced approach, ensure that the both creditors and borrowers are treated fairly during the recovery process. Speed up the process, as I told you earlier, of the debt recovery compared to the traditional court procedures. Now, we'll quickly go through the important relevant sections of this RD Act. We'll try to focus on the part of jurisdiction. We'll try to focus on the procedures, appeals, power of the appellate tribunal, and the amendment made so on. I also have a brief comparison for you guys. So we'll try to briefly cover all of this. Yeah. So we'll talk about the jurisdiction. Jurisdiction, and I know you all are law students and you guys are aware of the term jurisdiction, but jurisdiction in very simple term, if I would explain to you guys, jurisdiction is just a power or a capacity of a court to entertain the matter, and it is decided on different limits, pecuniary, location wise, etc., etc. So section 17 deals with jurisdiction. So debt recovery tribunal have the jurisdiction to entertain and adjudicate the cases where the amount of debt exceeds 10 lakh, and it was later reduced to 1 lakh by 2016 amendment, which will deal further as the session progresses. So the debt recovery tribunal handles appeals against the order of the DRT. Yes. So DRET, also I can also call it DRAT, is nothing but just an appellate tribunal. In the sense, if in a very simple term I would like to if I would like to explain the hierarchy of this, is like DRT is like the district court and DRAT is like the high court. So if you're not satisfied by the outcome of the single bench judge from the DRT, you can go and appeal in the DRAT. And throughout India we have 5 different DRATs and we can appeal there. Section 17 says that DRT has an exclusive jurisdiction over cases involving the recovery of debts owed to banks and financial institutions. Section 17 says that appeals against the order of DRT can be made to DRAT also. Now, what is the procedure? Procedure is briefly explained in from section 19 to 25. Section 19 of the RD Act says that a bank or a financial institution files an application to the DRT for the recovery of the debt. This is how, under next section 19, the whole process is initiated. Section 20 says DRT shall issue a notice to the borrower summoning them to appear and respond. Section 21, the DRT has the authority to pass an order for the recovery of the debt and can direct the borrower to repay the loan within a prescribed period of time. This prescribed period of time may vary on the amount of the debt also, and may vary upon different situations also. Secondly, DRT has the power to order the attachment and sale of the property to recovery the debt. So as I explained to you previously also, this whole process of recovery in the previous SARFAESI and the debt recovery process was somewhere or majorly was close to the auction process. So now, in if I would just give a additional information that how in NCLT today's days, how do we generally recover the money and how we used to recover the money earlier. So according to DRT or SARFAESI or any other recovery mechanism, if let's say I am a company or I am an individual, I have made a default, then the person who has lent money to me has all the right to seize any of my property which I've kept on collateral and take the possession of that. And after following few guidelines and regulation, after a certain period of time, they can put that property in auction, and then the highest bidder will take the property, and then the payment will be repaid. But on the contrary, the recovery mechanism in IBC is much more different and a much more in a positive note. So let's say under IBC, if I made a default which is exceeding an amount of more than 2 crore or 5 crore, and if I'm a company, so and I'm a defaulter, so my creditor will go and file an application in the NCLT, initiating the proceedings under section 7 or maybe under section 9 of the act. And then the whole purpose in IBC is also to recover the money for the creditors, and also to keep the defaulter as a going concern. Okay. Now, as I've already explained in the previous session, the concept of going concern means, let's say if I'm a defaulter, I've made a default, then then my friend comes and says that, okay, I know that Rohit has made a default, and he has made a default of 5 crores. Then my friend will come and say to the court or to my creditors, by keeping RP or the designated person from the court in between, and he will give an application, he will give a resolution to the parties involved, saying that he has made a default of 5 crore. I can provide 4 crores in return, but just in return, I will take over the company of Rohit. So what will happen by this? The loan will be repaid. My company and my employees will still be there, and the economy won't be troubled. So that is the major difference between the normal recovery process and the recovery process of IBC. Yeah. So coming back to the topic, so DRT can appoint a receiver to manage the property or assets or borrowing during the recovery proceedings. So this point is much more similar in all the processes, no matter DRT proceedings. So under SARFAESI or IBC, any authority, any quasi-judicial authority, no matter it might be DRT or it can be NCL or any other authority, they will always appoint any person in between to manage all of this. So in this DRT, we have a receiver. Under SARFAESI, we have a manager called RCO under section 4. And under IBC, we have a person which is appointed by the court or the authority, which is called as RP, resolution professional. So they are generally the bridging gap between the court, the recovering authorities, and the debtor. It is their responsibility to negotiate, not basically negotiate, but to recover the amount in a very speedy and in a very regularized manner. Section 24 of the provision says that provisions for the enforcement of DRT orders, all the DRT orders can be enforced under this provision by taking the support of this provision. Then prohibition on the attachment of certain assets, including the personal residence of the borrowers, unless it's a business property. So this section basically says that this section basically negates from the concept of limited liability, section 25, if you pay very close attention to the section, because it says prohibition on the attachment of certain assets, including the personal residence of the borrower, unless it's a business property. Now we quickly look at the sections of appeal. The provisions for appeal is dealt with section 20, 25, and 29. Section 20 allows appeal to the debt recovery tribunal against the orders of the DRT. Section 25 specifies the timeline which an appeal must be filed for. Section 29 grants DRAT the power to stay or modify the orders of DRT DRAT has the authority to confirm, modify, or set aside the orders passed by DRT. As I told you, it's an appellate authority and it has all the power to change, modify, confirm, etc., with respect to the previous orders passed by the DRT. And I think so, one of the major differences between any authority or appellate authority is the number of benches. An authority, let's say district court, will generally practice for a single bench or a division bench or single bench most of the time. But DRTs or appellate authority, we have multiple benches, division benches, benches of 3, 4, etc., etc. So that these appellate authority, they evaluate the orders and the matter in much more precise manner, because the matters are halfly done once they reach the DRT. The origin starts from DRT, and then after the order is passed, no matter it might be in the favor or against the creditor, it goes to the DRAT at a stage where it can be evaluated and assessed more properly in a regularized manner. Then powers of DRAT. DRAT has the power to hear the appeals from DRT. That's a very basic thing. DRAT can stay the execution of the orders passed by DRT and can modify even and set aside DRT orders, offering an appellate review of the debt recovery proceedings. So briefly, I would like to say the whole process of RDF is somewhat similar to the normal court proceedings, where the courts have to follow a hierarchy, where they have the similar powers as the appellate authority. It is just this RD Act has given special quasi judicial authorities, and they have created certain courts just for debt recovery mechanism. That is all I'm trying to make you guys understand. Now then, there was later we'll talk about the amendment that was introduced in the 2016. The amendment 2016 brought significant changes. It reduced the minimum debt threshold for filing a case from 10 lakh to 1 lakh. It streamlined the recovery procedure by providing timelines for the disposal of cases. Improved enforcement measures, including more stringent provisions to prevent borrowers from evading recovery procedure, fast track dispute resolution, which I already told you, through clear guidelines on the functioning of DRTs and DRATs. Then enhanced powers of DRT and DRATs to speed up the debt recovery procedure. Now, as we're almost going to coming towards the end, I just have a small comparison between RD Act and SARFAESI Act. The objective of RD Act focuses on providing a tribunal-based mechanism for recovery debt. SARFAESI focuses on enabling secured creditors to enforce their right without going to the courts itself. RDF establishes tribunal system, establishment of debt recovery tribunal and appellate tribunals. No tribunal system under SARFAESI. Banks and financial institutions can take direct action under SARFAESI. So this was one of the major key provisions and methods under SARFAESI, where there was a minimum court intervention that was required from the part of the authorities, but that was very limited to the nature under SARFAESI, because under SARFAESI only secured creditors can take advantage. Unsecured creditors have no priority given. Now, I know you all are aware of secured and unsecured, but I would still like to inform you guys just to make you guys understand the anomalies. Under SARFAESI, if I'm a secured creditor, let's say, what is a secured creditor basically? Basically, if I'm a bank and let's say my friend Varun comes to me and provides and says that I want a loan of 10 lakh, and in return I'll give you my property for 1 year and then I'll repay the loan. So now, since I have the charge created over Varun's property, I have an interest created on the Varun property as a security which is kept under my supervision, under my custody. I am a secured creditor. Whereas on the other hand, if a creditor comes and say I want 10 lakh rupees, then I will give you in certain period of time his uh, only on his words, if I've given him the loan amount without keeping any security under my custody, then I'm an unsecured creditor. So there was a lot of incident that happened that unsecured creditors never got any relief under SARFAESI, and only secured creditors got the advantages. So that was one of the drawback. Then speed of recovery, relatively slower, involves a formal process through tribunals because it has to go through all the appeals and it has to follow all the hierarchies and etc. So it is relatively little slow process. SARFAESI on the other hand is faster, as secure creditor can take possession and sell collateral without intervention, without court intervention. Secure interests debts are recovered through tribunal orders with possibility of asset attachments. Secure creditors can directly enforce the security interest without a court order. Now, what we'll try to quickly understand what were the challenges before the RD Act. There was a delay in disposal of cases. The DRTs are often overburdened with cases leading to delays in the resolution process. Enforcement issues. While the tribunals have the authority to order assets sales, the enforcement of these orders can be slow. Limited scope for certain creditors. RDF Act applies mainly to the bank, financial institution, leaving out small creditors and non-banking financial companies. And this non-banking financial companies, if I'm right to my knowledge, it is included under SARFAESI. Borrowers evading recovery. Borrowers may attempt to use legal loopholes and technicalities to delay proceeding and make debt recovery more difficult. So, as I told you, it has somewhat a court procedure only. It's somewhat a court procedure only. The masters of the court procedures, the person who have a very good experience in this field, they know how to take advantage of the loophole. So that's what is one of the challenges. Relevance to the insolvency and bankruptcy code. We'll try to quickly try to understand the relevance between both the statutes and the mechanism. Insolvency Code of India 2016 and RD Act both deal with the recovery of debt, but in different ways, as I told you. RD Act provides a framework for both banks and financial institutions to recover loans and debts throughout DRTs and DRATs. IBC is more comprehensive and covers corporate debtors, individuals facing insolvency, with a focus on restructuring and resolution of distressed entities in the time-bound manner. IBC is intended for more significant corporate entities or businesses, while RD Act handles smaller cases, especially involving debts due to banks and financial institutions. Both laws aim to reduce non-performing assets but take different approaches. IBC focuses on resolution and restructuring. As I already told you, resolution restructuring basically to keep a company as a going concern, keep a defaulter as a going concern. So resolution is nothing just but an offer. If I am a defaulter, I already gave an example. If I am a defaulter, if I made a default, to the person who is willing to pay my debt and get my company's restructuring and get my company's restructuring done and take over the management of my company, will come first with an offer to the court or to the RP and this committee COC, which is Committee of Creditors, and will say that this is my offer, that this much how much I can pay now, and that is known as a resolution. And he's also known as the resolution applicant, the person who's bringing on the offer to pay the debts and get the ownership of the company in return by paying the debt is known as the resolution applicant. And RD Act focuses on a quick recovery through tribunals. Concluding the session, I would like to explain that RD Act is an essential legislative framework that addresses the recovery of the debts due to banks, financial institutions, primarily through specialized tribunal. While it provides more efficient recovery system compared to traditional courts, there are challenges in implementation such as delay in such in case resolutions and enforcement amendments, particularly in 2016, have made the system more accessible and efficient because of the reduced limit of the pecuniary limit. Earlier it was 10 lakh, now it's 1 lakh. When compared with the SARFAESI and IBC, the RD Act serves a complementary role in the broader financial resolution ecosystem. For conducting your online session, and that's it. That was the last part. Yeah, so that was all about it. I have briefly explained you about each and every part, which was I thought which was important to get started with all this IBC process. We have briefly covered about what is DRT, what is DRAT, and other procedures also. And basically, as I told you earlier also, if you guys are interested in this field of insolvency, it is a booming concept. It is a booming field where I would say the cream of litigations are practicing under IBC, and they are doing really well. So I would like to just give an example. When I was working at a place, I was interning at a place long back. My senior just told me to keep track of the matter and see who all person are coming next to us and inform me when our matter will be there in the court. Well, I was keeping the track of the matter that was right before our matter in the NCLT. I saw Mr. Kapil Sibal pleading before the court. And I was surprised to the fact that at that time, the proceedings of NCLT were very new in the market. And I thought that how can Kapil Sibal, such a big name, come before the court and do a proceeding? So that's when I understood that it has a lot of scope. So I would really request you guys to please stay connected with the legal law and take full advantage of the course which Varun and Parth are providing you with respect to insolvencies. Write it down to me or Varun, and just please let me know if there is anything if you guys want us to cover. And thank you so much, Legal Lock. Thank you so much, Varun, Parth, everybody. Thank you for giving me your time. I hope I made sense. I hope I could explain everything. Thank you so much.